U.S. Supreme Court heard oral arguments in the consolidated case Trump v. CASA. This is a case that examines the ability of lower courts to issue nationwide injunctions against presidential actions. And as you can imagine, the case is being very closely watched, as it certainly has implications on constitutional issues. Goodness, things like birthright citizenship, judicial overreach, and just a host of things. But what exactly was argued, and how might this affect the political future of America? Well, joining me now to discuss this is Josh Hammer. He's the senior counsel for the Article 3 project, as well as the Internet Accountability Project. He's also an active member of the Texas State Bar, and he serves also as a senior editor-at-large for Newsweek, in addition to hosting a number of podcasts where he frequently touches on political, cultural, and legal issues. Josh, welcome back to Washington Watch. Great to have you.
It's a pleasure to be here. Thank you.
Okay, this is a big case that the Supreme Court is reviewing right now. What are some of the prevailing arguments in this case?
So I think the most interesting thing, Jody, about this particular case is that it is a birthright citizenship case that is not currently being litigated, at least before the justice, as a birthright citizenship case. So let's be very clear here. I mean, this does emerge out of the executive order that President Trump signed within the first hours of his presidency, interpreting Section 1 of the 14th Amendment so as to not require birthright citizenship as a constitutional requirement for the children of legal aliens born here. I have argued for many years, including just over the past few months, that this is indeed a correct interpretation of the 14th Amendment and its citizenship clause. But Trump's lawyers, namely the Solicitor General of the United States, John Sauer, who's a fantastic attorney, former clerk for Justice Scalia, who's also a former SG of Missouri, very brilliant lawyer. I think what he basically decided here, Jody, is he was basically just counting the votes, and he decided that there were not 5 solid votes for that view, even though it is the correct view. So he made a tactical decision to argue this on Thursday at the court as about the scope of relief here. And this is a very legal way of saying here that what we're actually talking about is the legitimacy of the so-called nationwide injunctions that the lower court judges slapped on the Donald Trump executive order. So I'm not expecting a ruling from the courts to probably even touch the actual substantive 14th Amendment issue. I would be very surprised. They're probably going to stick just to the actual judicial power question as to whether or not these nationwide injunctions are proper, to which I personally have a very simple answer, which is no, they are wholly improper. They are wholly illegitimate there. The judicial power of the United States does not encompass the ability of a rogue, random, one-off lower court judge to bring an entire federal government program to a hilt. This is simply not the system, Jody, that our founding fathers devised. The judiciary, as we know from Federalist Number 78 with Alexander Hamilton, was always supposed to be the least dangerous branch. And as Abraham Lincoln put it in his first inaugural address of 1861, to make all of the great political and legal questions and to put that in the hands of the judiciary as the sole, final, and binding arbiter of these questions would essentially mean that we, the people, have ceased to be our own rulers. So this is not the system that we signed up for. This is not the reason that the patriots of 1776 rebelled against King George III in the first place there. I am cautiously optimistic that the justice will do the right thing, but we shall see.
Okay, so when we're talking about a nationwide injunction, you covered a lot of ground there, but basically we're talking about a lower court judge dealing with a specific case, making a decision, and that decision having national enforcement, national implications, rather than just on the case before the judge. Is that correct?
That's exactly correct. Yeah. So the whole question here, among others, I suppose, but really the key question is what are the legitimate confines of the judicial power, which is the first line of Article 3 of the Constitution. And for what my money is worth, my reading, Jody, of the judicial power is that a court has the power to bind the parties before it, to bind the plaintiff and the defendant there. You frankly don't need to be a legal scholar here. All you need is some good old-fashioned common sense. I mean, if John sues Jane and they end up in court there and the court issues a judgment, it is John and Jane who are bound. You know, Tommy, who's back at home munching on potato chips watching TV, he's not bound there. If Tommy ends up getting dragged into court for a similar lawsuit a month, a year from now, whatever there, that judge can view the previous suit as persuasive authority, but Tommy is not bound by that judgment.
Okay, that's a great analogy and a word picture there. So tell me this. You are certainly of the opinion that the ability to issue these nationwide injunctions violates not only the Constitution and not only the role of the judiciary, but even self-governance itself. All right, run down that path. Why? Because I think that's an extremely important part of this whole thing that people need to understand. So unpack that for us, if you would.
Sure. So we're dealing here with a system of judicial supremacy, with this notion that not just the judiciary, but in this particular case, that lower court judges, district court judges, even court of appeals judges, we're dealing here with a system where they are supreme because they have the power to nullify any congressionally enacted law, any president's executive order there. And this is simply not the judicial review that this country was founded on. So, Jody, a lot of people like to talk about the 1803 case Marbury versus Madison, which we will recall from our high school civics and whatnot there. So that was the case where Chief Justice John Marshall says that it is emphatically the province of the judiciary to declare what the law is. This is the founding of judicial review. But people forget what Marshall said in the sentence directly after that. What Marshall said in the sentence directly after that is that, well, you're going to have to then interpret and expound upon the law in particular cases. That's the key point, Jody, in particular cases there. Judicial review in our system has to do with specific cases, specific litigants. That's the John Jane example there. There's no notion that the judiciary is the sole, final, exclusive, final binding arbiter of legal questions there. That is tyranny. That is judicial tyranny, is black robe tyranny. It might be a little less authoritarian than various other forms of tyranny that have existed, but it is ultimately just a similar stripe of tyranny, the very likes of which the founding fathers and those brave men back in 1776, the reason that they rebelled against the crown in the first place there. The judiciary has a role, but it is a very limited role. And ultimately, Jody, they have to know their place when it comes to Congress and the executive branch.
Could not agree more. I want to thank you, Josh Hammer, Senior Counsel for the Article 3 project. Great job bringing this before us and making that, which is quite complicated, understandable. So thank you so much for joining us today on Washington Watch. We'll be keeping a pulse on this. Look forward to talking to you further.
My pleasure. Thank you so much.